Hello, everyone. So, now we are going to start with the next topic, right? So far, we have not even started with Companies Act, right? All we have read about is what are the basics of law, how are we going to study. Then we started with the basics of company and the features of company, right? So only one question so far which can be asked in this examination is the what are the features of a company. Today the first topic that we are going to do is corporate wheel, or rather I should write lifting of corporate wheel, and this is the second question which may be asked in examination. So what can be the question? Elaborate the concept of corporate wheel, or in what cases corporate wheel may be lifted. I should write lifting of corporate wheel. Fine. So these type of the similar questions, just a language here and there, may be formed and may be asked to you, right? And this is actually asked in examination. Features of company is very, very basic and is rarely asked, but this is a question which is often asked. So we have to prepare ourselves well and we have to learn this particular concept well as to what to write in examination so that we are getting full marks. Okay. Now, I told you the entire law that we are going to read and study is going to be based on two parameters, why and how. Right. So, why do you think lifting of corporate wheel is going to be done? Now, first of all, we actually want to know what do we mean by lifting of corporate wheel. Basically, we are lifting something. Basically, we are lifting something. Now, if I tell you one basic thing, okay. So this, ah, I want the screen to be off. Okay, let's take it this way. Okay, so let's say this is I have put something behind this particular phone. Can you see it? Can you see it? The answer is no. If I lift this phone, can you see what is behind it? Yes, ma'am, there's a whitener that you have kept over here, right? So, till the time this whitener has been covered by this phone, we cannot actually see what is behind it. The same is the concept of lifting off corporate wheel or the concept of corporate wheel. Now, let's say these are the two friends who formed a company. So they are the ones who have invested in the company 50,000 by this, 50,000 by this. Now they both decided that okay, we have put our money in this company, but who is going to manage the company? Because there are so many tasks which have to be done by the company, and the management of the company has to be done by the directors. So, should we hire the directors from outside who are like professionals and they can do everything? Or are we good enough or competent enough? Do we have the time and expertise to manage the company? So, they decided why not? Let's be the directors also. So, they are the members and they are the directors, right? So, every decision that this company is taking is taken by these two. Yes or no? Of course, ma'am. Some decisions of the company are taken by directors. Some decisions of the company are taken by shareholders. Because company, although is a separate legal entity, has an independent corporate existence, but actually cannot see anything. Like if there is someone who is coming to deal with the company actually cannot identify the intentions, whether it's correct, whether it's incorrect, whether we should go for it or whether we should not go for it. So these are the persons who actually take decisions on behalf of the company. But if anything goes wrong and anyone comes, like the government comes, company, you have not filed this particular, Company, I am filing, I am filing. You are penalized for 5,000. Okay, I'll pay. I will pay. What do we see? Company. We don't see the real people who are doing this. Well, that is the beautiful concept of separate legal entity or independent corporate existence. This is a concept which prevents these people that they can work in the best interest of the company. They are doing their job, they're doing everything nicely, so they will not be responsible for the defaults, for the problems of the company. Only company will be responsible. That means after the company is incorporated, listen to me very carefully, listen to me very, very, very carefully. After the company is incorporated, after the company is incorporated, the company becomes a separate legal entity. Okay? The company becomes a separate legal entity, and there is a wheel of incorporation which protect its shareholders or the directors. Get it? Okay. So, ma'am, what do we write over here? What do we write over here? I'm making you write the first line, then I'll make you write the second line, and thereafter there will be different points which you have to write. So these points are more important, but the introductory two lines also you will write in this particular question. Okay, so what are those two lines? Answer: when a company is incorporated, it is considered as a separate legal entity. This separation is called as corporate will, which protects the members from incurring personal liability. Right. So, for all the problems, the company will be liable and they will not be personally liable. So, this is the first line. However, now we're talking about the lifting or piercing of corporate veil. However, sometimes courts may dis may disregard this concept and ignore the independent existence to look behind the real, or write it this way, to look at the real persons behind companies' actions and make, or just put a full stop. This is called as lifting or piercing of corporate veil. Okay. Following are the cases where courts have lifted the corporate veil. Okay, So these are the two lines. First line tells us what do you mean by corporate wheel. The second line tells us what do you mean by lifting of corporate wheel. Lifting of corporate wheel basically means to disregard the corporate entity and look behind the real person. So whenever law or the courts, you can also write sometimes law oblique courts, okay, law or the court, they ignored this particular concept, it means that corporate wheel is lifted. That means now we want to see who is the real person who is doing this. Why? Because a company cannot do any fraud. So if there is somewhat a case of fraud, that means the company is not the company is an artificial person. The company cannot do any fraud with anyone, right? It is actually the people who do fraud, right? So we need to see who is the one who is doing this. So we will punish that people. Although they are separate entities. I have not done any fraud. No, now you're one and you are going to be responsible. We will treat you responsible. You will be penalized for that. So that is what is basically happening. Okay. So now we have different cases where the courts have lifted corporate wheel. There are also laws which have been made where the lifting of corporate wheel is done, like whenever we read Companies Act, we will see, and a lot of places I will tell you that, see, the company is liable, but the penalty given is company will be liable to pay a penalty of 10,000. The officer in default will be liable to pay a penalty of 5,000. That means the person who was responsible and did not do, he is also penalized. He's also penalized. So if you're a director of a company, doesn't mean you can get away with anything and everything. No. As long as you're doing everything in good faith and you're not doing anything wrong, it's fine. You will not be penalized. Even if there is losses, even if there is anything, company will be responsible. But when you are doing anything which you're not supposed to do, then you will become liable. Because then corporate will be lifted and you will be seen. Got it? Okay. Now, following are the cases where courts have lifted the corporate wheel. Case number 1. Case number 1, ma'am, how are we going to write it? How are we going to write it? Again, you can write like A, B, C, D. You can write like 1, 2, 3, 4, or you can use simple bullets like this. Okay, so the first one, in certain matters concerning law of taxes, or you can say duties or stamps. Okay, in certain matters concerning law of taxes, duties or stamps, where the question of controlling interest is in the issue. Where question of controlling interest is an issue, is there. You can write simply. Now, ma'am, we need to learn this much. See, I am highlighting it. This is something which you must learn. Okay, so this is exactly, you have to write like this only, in certain matters concerning law of taxes, duties, stamps, etc. Okay, where the question of controlling interest is there. If you are capable to learn that, you can. If you're not capable, it's completely fine. Now, let's understand this particular point. We have a beautiful case law of Dinshaw, Menegji, Pettit. Ma'am, do we need to learn the case law name? The answer is no. I'll tell you a few case law names which you should remember from exam perspective, but this one, no. Then what are we reading, ma'am? We're just reading an example. So this example you can write, but you're not supposed to learn this. Fine? Okay. Now, we have a person called as Dinshaw. Let's say we have a person called as Dinshaw. Now, he has many investments. And when he has many investments, he has heavy profits, which means heavy taxes. Okay. Now, I hope you know that when you're reading income tax, you know that, okay, we have, just like we have slabs, right? If we are earning above this particular threshold, we are subjected to surcharge, etc., etc. So, which means if you have profits more than this, there are very heavy taxes. So, what he decided is he actually formed different companies. Okay, he formed different companies, and these companies took over his investment. These companies took over his investment. Now, what he thought, okay, what he thought that this is going to be the ideal situation. Well, Mr. Dinshaw, I am different, and the companies that I have formed, they're separate legal entities, so they are different. So every company has their own set of investments and they're supposed to pay their own taxes. So the tax burden, although ultimately he is only paying all the taxes, but the tax burden reduced a lot. But court said no. Through this process of formation of companies, because you have formed the companies only for the sake of reducing your tax burden, right? So court said no. In this situation, we will not consider you separate entities, but we will consider you same entity. What is lifting of corporate wheel? Disregarding the concept of separate legal entity, that means considering both entities to be the same. So now when you consider them the same, that means all the investments which this company had were clubbed into the investments of Dinshaw, and accordingly he was taxed. Why? Because if we consider this concept of separate legal entity, there will be tax evasion. He was trying to reduce the burden of tax. You get it? So, very first point, in certain matters where law of taxes, duties, stamp is in question. Okay. So, who has that control? That is there in the question. Point number two. Point number two. I hope everyone is writing with me. It's very important. This is the writing practice that we're doing. And in the initial classes, we're very relaxed. We can, of course, because right now we're just trying to know each other. We're just trying to develop that sense of comfort, right? So, right now, I will also go very slow, and you get the time to adjust to everything, set of patterns, set your timing, fix everything. Because once the space increases like this, you will then face problems. Okay, so the second point, in law relating to trading with enemy, where test of control is checked or is adopted. Again, what you have to for sure remember is this part. Okay. Trading with enemy, where we have to check whether it is our enemy or not. Now, let's say, let's talk about the World War. Although there are many households where you'll see that every morning there's a big hustle, there's a whole world war going on, right? But right now I'm talking about the real World War, World War One. That means there are different countries against each other, right? Now, if let's say there is a neighbor, okay, and your mother had a fight seriously with that neighbor aunt, right? So you now that aunt actually has a beautiful daughter which you really like and you have a big time crush on, right? Now listen to me very carefully. Even if you want to talk to her when your mother is not in talking terms with the neighbor aunt, can you? At least not in front of your mom, otherwise you'll be beaten big time, right? So you cannot do that. In the same manner, we live in a nation. The nation is at war with another nation. Yes or no? Yes, ma'am. So when two nations are at war, even if you have very good terms with some company of that particular nation and you want to trade, you want to enter into a contract, can you? The nation will beat you. Why? Because it is not allowed. When one country is at war with another, the other country becomes enemy country and not a friend, right? So all the citizens, all the entities of this country will be enemy entities, right? So if you are entering into any contract, you cannot, because it's trading with enemy. It's trading with enemy. Now listen to me very carefully, right? Okay. So we have basically again a case law, Daimler, but we are not considered about the name, so I'm not getting that much into the detail. Daimler, let's say, was a British company. Okay. And then there was a Continental Tire, there was a company which was registered in British, registered in British, but controlled by Germans. Okay, which means most of the directors and shareholders were German. Now you tell me, if we look only this much, if we look, what is it's charged? So if we look only this much, we will see that I am a British company and I am trading with another British company, right? Because company is different from its members. So it has a separate legal entity. So I'm dealing with another British company. So we are not enemies, but ideally, this British company is only registered in British. It is actually controlled by the Germans. So when we want to check whether that entity is our enemy or friend, then we need to see who are the persons who are controlling it. So in this situation, it was established that in this case, we will lift the corporate wheel and we'll consider them as one. And then we get to know that this is our enemy and not a friend. And hence we cannot trade with this. Okay. Is that clear? Fine. Next point. Next point. Now, sometimes companies form other companies to act as their subsidiaries, where companies form other companies to act as their subsidiaries. Of course, there's nothing special that I've written over here. Now, what do you mean by this particular point? See, although this particular point, I will also tell you that if at all you can remember the case law, it would be really great. Smith, Stone, and Knight Limited. Smith, Stone, and Knight Limited, which we also like in short, you can remember it as SSK Limited. Smith, Stone, and Knight Limited. But I'm not writing this because I don't want my students to be learning this short form. Smith, Stone, and Knight Limited versus Mayor, or you can rather write Lord Mayor of Birmingham. If you cannot learn the entire thing, even if you learn this much, it is fine. In the case of Smith, Stone, and Knight Limited. Okay, in the case of Smith, Stone, and Knight Limited, you can say that. Okay, now. Although I have not explained you the concept of subsidiaries yet, but the basic you know that if we have one company, ABC Limited, and this particular company holds, let's say 95% shares of another company, PQR Limited, you basically know that this is going to be a subsidiary and this is going to be a holding. Yes or no? Yes, ma'am. Okay, so we have a subsidiary and we have a holding, right? Now we have this case law where Smith, Stone and Knight Limited, they had a subsidiary. They had a subsidiary. Okay, what was the subsidiary? There was another subsidiary. You don't even need to get into the name of that subsidiary. We have Birmingham Waste Company Limited. So they had a subsidiary, right? This company was doing paper, waste paper business through its subsidiary. Okay, through its subsidiary. Fine. Okay. Now, Birmingham Corporation. Just like we have municipal corporations in our city. Every city has municipal corporation, right? They are responsible for that. It's a local authority, basically, right? So in the city of Birmingham also, they had Birmingham Corporation. Okay. Now they compulsorily acquired the land on which this business was done. Right? So they said we will give the compensation to anyone who is to the person who is in possession of that particular land. Now, who was in possession? The subsidiary. Why? Because subsidiary was doing business. But the business was ideally of the holding company. The business was ideally of the holding company, right? The whole point and the whole question was, I will just sum this up because it's a little complicated case law. Let me state the facts first, then it will be easy for you. So we have an SSK Limited, then we have a subsidiary, and then we have this Birmingham Corporation. Okay, so these are the three parties in this particular case law. SSK Limited, they had the land, right? It was their land, right? But the business was done by subsidiary. Business by subsidiary. So SSK Limited not in possession of the land. Why? Because the business was done by subsidiary. So subsidiary was in possession of the land. They acquired the land. And said, we will give the compensation only to someone who is in possession. So SSK Limited said, fine, it is our land, but we are not in possession. Give the compensation to subsidiary. They said, no, it's not their land, right? And you're not in possession. So no loss to you, nothing like, so we will not give any additional compensation that we are supposed to, etc., etc. Okay. So in this situation, SSK Limited was stuck. Later on, they realized that they had not really transferred the business also, and moreover, they had made the subsidiary only to make this subsidiary as their agent. So they were ideally doing the business through their agent, and this particular subsidiary, Birmingham Waste Company Limited, was ideally doing nothing. Okay, so this particular subsidiary is not meant and formed for any other purpose but for only doing what is being instructed by its holding. So ideally they are like one entity only. Why consider them separate? Although subsidiary, they are two different companies, they should be considered separately. But in this particular case, because this company had formed just to do that business, just to get through all of that, they were considered to be one, and accordingly compensation was given to this holding company. So held that SSK was doing business and subsidiary was merely an agent, so entitled to compensation. So it was established that no, I am only doing business on that particular land and this is only my agent. Okay, it's not that this is a separate company doing some business. No, I am only doing that business. Fine. Okay. So when you form subsidiaries just as mere agent, then the concept of corporate legal separate entity will be disregarded. Point number 4. Avoidance of welfare legislation. Avoidance of welfare legislation. Okay, again, I am writing the case law over here. Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. Okay. What is legislation? Law. What is welfare legislation? The law which is made for welfare of someone. For whose welfare? For whose welfare? For the welfare of workers. So basically, we are talking here about bonus. It could be any welfare legislation, but the case that we have written over here, we are talking about bonus. So we have a company, Associated Rubber Industries Limited. This particular company formed another subsidiary. Why? To shift profits. To shift profits. Why? Because if you have this much profit, you need to pay this much bonus. If you have this much profit, you need to pay this much bonus. If you have this much profit, you need to pay this much bonus, right? So the bonus will increase according to the profit. So if somebody is having very high profits, they also need to provide bonus, because we have a proper code on wages where we talk about the minimum bonus that has to be paid to the workers and everything. You have read that, right? So accordingly, bonus has to be paid. So they thought that why not reduce the profits only? So I'll shift half the profits to another, and then the employees are here only, so they will be getting this much bonus only. So I'll accordingly reduce. So I'm trying to avoid the welfare legislation. I'm trying to avoid the welfare legislation. In this situation, the corporate will be lifted and they will be considered as one, and accordingly the profits will be joined, and accordingly the bonus has to be paid. Got it? Okay, ma'am. Next one. Next is the case of fraud or improper conduct. So the courts will lift the corporate veil to find the reality in case of fraud or improper conduct. To find reality in case of fraud or improper conduct. I told you in the very beginning, in fact, we have a case called as Jones versus Lipman also, where the company was formed to defraud its creditors. What do you mean by that? What do you mean by that? See, there are two intentions. Your friend comes to you and asks that, can you give me 5,000 rupees? You said, okay, he might be in need and I am blessed, I can give. So you gave 5,000 rupees to him. He's not able to return it. He's not able to return it. Will you shout? Will you be angry? No. You'll first try to find out why is he not able to return it. I'll share with you an example. I had a friend, and that particular friend took an amount of like 5,000 only, I guess, from me. And then later on, I always thought that she is somebody who is not able to afford it, right? So she is barely like surviving hand to mouth. So why should I take that money back? Why should I ask for it? But when one day I like saw her that she is spending lavishly on everything around. That means if she's going to a restaurant, she's like going to Starbucks, ordering coffee like that. Why? Then I somehow didn't feel good that she has taken my money, and I thought that she is very much in need, but she's actually trying to defraud me. She has the intention of not repaying my money. She took the money with the clear intention of not repaying it. Then I went to her and I asked for it. Right. So, in the same way, you will also feel bad when the other person is like, oh my God, so you have all the money in the world and you cannot, you were like, I don't have money, please give me money, etc., etc. So, now you know the intention of that person. So, when the intention is clear, that okay, you have formed the company, that you will take raw material on credit and then you'll show losses and you will not be able to repay it. So you have formed the company with the intention of defrauding the creditors. In that situation, we'll not consider the company different from you all. We'll club it and you will be personally responsible. Okay. Next, to protect public policy, to protect public policy, or prevent any transaction which is contrary to public policy, or prevent transactions contrary to public policy. Ma'am, what you're writing, is it sufficient to write an examination? More than sufficient. Okay. Whatever I have written over here, this is exactly what you'll write in examination and you're going to get full marks. Trust me on that. Got it? Okay. So here we have, of course, a case law, and that is Connors versus Connors Limited. Okay. What is this case, ma'am? This case talks about public policy. Public policy means what, ma'am? See, supposedly there is a company which is violating law or maybe against public health or safety. Like maybe there is a pharma company which is manufacturing a drug which is against the safety standards. So it is against public policy, right? So this particular thing, if a company is doing, it's not alone that the company should be held responsible. We should actually lift this corporate wheel and look behind the real persons who are doing it. And they should also be held responsible, right? So whenever there is unethical business practices or maybe public health, public safety, that is being threatened, that is being hampered, there is violation of law. So that means this particular thing invokes and lifting of corporate wheel is done. Next, we have if company is or company abused the corporate. Abused means what? Misused. Abused. That means you are not using the company for the intended purpose. You are misusing the company. Abused the corporate personality for unjust purpose. Unjust means which is not justified. Which is not justified. It could be any of the reason, maybe fraud, maybe evasion of any legal obligation. So this is a broad point which covers all other remaining points. Come on, everyone. Now, enough of just noting the points. We are going to repeat it all. What are the points? What are the cases where corporate wheel may be lifted? Point number 1. In certain matters concerning law of taxes and duties. You are supposed to repeat after me, with me, even if I'm not listening, right? That is how you will learn. You have to be at least honest to your own self if you're just listening to me like that. You're not honest to yourself. Trust me. See, you're still a student. No matter whether you're in finals or you're in foundation, you're still a student, right? And I feel throughout the life, you should stay as a student. So keep on learning. And you have to score marks, yes or no? So to score marks, it is very important that you have to, I'll also tell you the revision strategy which you're basically supposed to do, because right till now, we were not doing anything which I wanted you to revise, but today I'm going to tell you something. But right now, repeat with me. In certain matters concerning law of taxes, duties and stamps, in law relating to trading with enemy, companies form other companies, the cases where companies have formed other companies to act as subsidiaries, avoidance of welfare legislation, to find out the reality in case of fraud or improper conduct, to protect public policy or prevent transactions which are contrary to public policy, where company abuse the corporate personality for unjust purpose. Okay? Unjust, unequitable, not justified, anything. Okay, next one, in the case of Kasi criminal cases. What is Kasi criminal cases? Right, like this. In case of Kasi criminal cases, basically when company is being again misused to commit a crime. Okay, so we have to see the real persons who have actually done the violation. Fine. Okay. And the last one. So there are some points which were very technical to understand, some points very easy. And again, the last one is a little technical. Okay. In case of transfer of shares which actually was sale of land. What is this, ma'am? Again, let's take an example. In fact, if you want, you can write this example also. Example. So we have two people. We have an state officer of Chandigarh, and then we have SEs, Information Technology Limited. There's a company, Information Technologies Limited. Now, this particular company was allotted a land. Okay, it was allotted a land at IT Park in Chandigarh, fine. And the condition of allotment was that no transfer allowed for 10 years. So there was a lock-in period of 10 years. Without taking the permission, you can't transfer this land for 10 years. Now, this particular company, what they did is transferred not the land, but transferred more than 90% shares to another company. So what happened? Ideally, right now the control of this particular company was with me because these were the shareholders, right? Supposedly, there's a company and this particular company owns this company or something like that. The control is with some people. Now, this has been transferred to another company. The land is still in the name of SE's Information Technologies, right? Because the company goes on forever and ever and ever. So the land is not transferred, but the control is being given to somebody else. So general view is that, okay, fine, the property is still with SEs and the company is different from its shareholders. So it doesn't matter who the shareholders are. The land is still in the name of the company. There is no change in the name of the allottee. So where is the violation? The condition was that there shouldn't be any transfer for 10 years. There is no transfer for 10 years. The allottee is still the same. The person who owns the land is still the same. This was the general view. But the state officer of Chandigarh said that there is violation. How there is violation? Because SE's Information Technologies Limited, first, they did not inform the state officer about this transfer of shares. So they were guilty of concealing the truth. Plus, they have violated the provisions of allotment letter. Why? Because the control of land has been shifted to another entity, and that was also not allowed without permission. Because when they see certain things, they see a certain promising venture, and that is why they have allotted the land in that IT park, that they'll see this development, and they have transferred the shares to somebody else. Without the control of land is with somebody else, and what they'll do, we don't know, right? So basically, it was not allowed without permission, and this resulted in the lifting of corporate veil. Okay, so basically the cases of transfer of shares which actually result in the sale of land and violation, then in those cases also the corporate veil will be lifted. Is that clear? Okay. Now, we have written all these points, yes or no? Yes, ma'am. This is an important question asked in examination, and you have to learn it no matter what. So, here comes the first learning thing. How many points have I written over here? 1, 2, 3, 4, 5, 6, 7, 8, 9. So, there are basically 9 points which I have written over here. When are you going to learn this? Today. Today. That is first revision plus learning. Plus learning within 24 hours. Then what you are going to do is second revision after chapter ends. Recall the entire chapter and note what you forgot. Forgotten part to be revised within 3 days. Then appear for mock test. This is how you are going to revise. This is how you are going to revise. Okay. So whenever you are done with the class, what you have to do is within 24 hours, maybe immediately after the class, if you have time. So like if I tell you, now onwards, forget about the earlier classes, you will have a class of 1.5 hours. So I suggest everyone that okay, you are giving 2 hours to law every day. So 1.5 hours of class, and thereafter half an hour, that is 30 minutes for revising the content that you have read in the class. Right now, I know it's going to be very simple, very basic. Wow, why do we revise lifting of corporate wheel? I know everyone knows the concept. Maybe you have read all these case laws and everything. But do you remember exactly what to write? The answer might be no. But do we need to learn this? The answer is absolutely yes. To score marks, very well marks in law, you need to learn this. So just after the class, 30 minutes, you will repeat it as many times as you can. You will just close the book and try to recall all the points. There are 9 points. Am I able to recall all the 9 points? Yes. Am I forgetting a particular point? Yes. Let me note down that particular point. Let me try it at the end of the day once again for 5 minutes. Am I able to recall all those 9 points before getting to sleep? Right? So am I able to do that? You have done that within 24 hours. So that is somewhere in your short-term memory now. Now, once the chapter ends and you revise it completely, thoroughly, and you are able to recall it, it is somehow shifts to your permanent memory. Permanent memory doesn't mean permanent forever. You will still forget it. But right now, at least for a slightly longer tenure, right? And thereafter, you will wait for 3-4 days, then revise it well, and then appear for the mock test maybe on a Sunday or any time, and then check your progress. So this is how you're supposed to do it. So I hope everyone is going to follow the revision. Okay, let's now move to the next topic. Now let's open the main book. Okay, so here is your main book. We will have a look at the applicability before we proceed further. The applicability is very simple. We know what is company. Company means companies registered under the act or under previous law, right? So this particular companies act is going to be applicable on the companies which are incorporated under this act or under any previous company law. Okay, apart from this, it will also be, not apart from this I should say, but it will also be applicable on insurance companies, banking companies and electricity companies, because they are also companies only, right? If I talk about Axis Bank, it is a company only, Axis Bank Limited, right? Now it is a banking company. Why? Because it is a company plus doing banking operations. That means it has to obtain a license to do banking from RBI. Yes or no? Okay, ma'am. So it is a company also. So it will comply with all the features of, and it will comply with all the provisions of Companies Act. But because it is in banking sector, it also has to listen to RBI. It also has to listen to its governing act, which is Banking Regulation Act. Yes or no? Now the problem comes. See, till you are single, you only listen to your parents, and that's fine. But once you're married, so till you're only a company, you only listen to Companies Act and you're all good and all fine. But when you get married, that means you were already a company, now you are a banking company. So now you're married. Now you have to listen to two people. One is your mother, the other is your wife. Who do you listen to? This Companies Act, this Banking Regulation Act. So you keep on listening to both. You keep on listening to both. Because they both are maybe saying the same thing. Both are telling you to get up early. Okay, fine, I'll get up early. Both are telling you to eat your lunch and put your plate in the sink. Okay, fine, you're listening. Right? But then comes a stage where your mother says something, your wife says something else. Now comes a problem. So the problem will be when these two provisions are inconsistent with each other. That means there's a conflict between Companies Act and Banking Regulation Act. Now, who do I listen to? Well, this particular problem doesn't have a solution. And once you're married, you have to discover your own solution and you have to resolve this own position. But because I am your law mentor, I have a solution for this particular conflict. And that is, whenever there is any inconsistency, then you will listen to your specific act. That means Banking Regulation Act, or it could mean Insurance Act in the case of insurance companies. It could mean Electricity Act in the case of electricity companies. So Companies Act is applicable to all the companies. In case of banking, insurance and electricity companies, it is applicable only where the provisions are, or except where the provisions are inconsistent with the provisions of their specific regulatory acts. And it is also going to be applicable on any body corporate which has been notified by CG. Okay, so like we have NHAI, we have National Highways Authorities of India. So it is a body corporate, it is not a company, but then provisions. So it can be notified. Fine, central government may notify. Is this clear? Is this clear, everyone? Very basics, and the question is not asked. You have read this before, so I'm not going to invest much of time in this particular topic. The features we have already discussed. Then we move to the provisions of corporate veil. I have already told you what is corporate veil, and I have made you write all these points, right? And I have told you what you have to learn, what you are not supposed to learn. So all these points we have already done, and now we are going to begin with this. Nature of business organization in India. Then we will move to classification of companies. Okay. Nature of business organization in India. Now, see, a lot of places you must have seen that people are doing business. Yes. And people are doing business to earn profit, right? But then there are many basic needs of the citizens who are living in the nation, right? Basic needs, that means if we want to travel from one place to another, right? We use, of course, we could use a road transport, right? We could use railways, right? Even when we are using roads, then that is something which is basic infrastructure that everyone needs, right? When I'm talking about railways, do you think that everything in India, particularly, let's talk about our nation only. So everything in India can actually be privatized. Well, slowly and gradually, we are seeing in all the sectors, maybe privatization is being incorporated. But even at a lot of places right now, the government is working. The government owns a lot of entities or enterprises, and the motive is not profit. Motive is social needs. Motive is social needs, right? So basically, when I talk about public sector in India, public sector means those enterprises or those entities which are controlled, owned, and managed by government. When I say government, what do you mean by government? Government could be at the central level, that is central government or state government, or maybe jointly by both of them, right? Now, when I say public sector, it is not for profit, but to cater social needs. Maybe it could be like economic development, it could be social welfare, to cater social needs. Okay. We have three types of government owned, managed, controlled enterprises. What are the three types? Departmental undertakings are basically the oldest thing that you will ever find, right? Because it has been here since long. And see, government, it is not something which is a legal entity. When I talk about Indian Railways, right, or Indian Post, or maybe Telegraph, it is not something which is a legal entity. But when I talk about statutory corporations, they are all legal entities, and they are incorporated, or they come into picture by act of parliament, by an act of parliament. Like we have LIC Act, through that act LIC is formed, right? Here, when I talk about companies, government companies, that means it is a company registered under Companies Act, in which 51% or more shares are with government. Like we have ONGC, like we have SAIL, like we have BHAIL. We have a lot of companies. You know about the Maharatna companies, you know about Navratna companies, right? Mini Ratna companies, whatever you may call, right? So we have ONGC, SAIL, BHAIL, GAIL, right? They all are what? Government companies where 51% or more shares are held by government, right? When I talk about statutory corporations, when they are established by an act of parliament or state legislature, they have a proper legal identity, right? But when I talk about departmental undertakings, they are directly through the ministry. Like we have central government works through its ministries. Then we have in ministry, we also may have department, right? And then comes your maybe Indian Railways, right? Likewise. So where do they get money from? They get money from the budget. You know that every year we have a budget. That means some funds are being allocated towards this purpose also. So they get money directly through their budget, and they have to prepare reports and everything, but they're not a specified legal entity. You get that? Got it? Okay. So, on the basis of government ownership, there could be a public sector which is completely owned, controlled, and managed by government, and there could be a joint sector where government have invested between 26 to 50%. If it is more than 50%, it is the public sector, because majority control is with the government only. If the control is more than 50%, it is majority only, right? So this could be government departments like this, it could be statutory corporations like this, or it could be government companies, the more detailed of which we will read in section 2, clause 45. Okay, just for your knowledge, you can also see this, a comparison, because often students ask a lot of questions. Department undertaking, there is no separate legal entity, and it is 100% owned by government. This is a separate legal entity, and it is fully owned by government usually, right? This is a government company where more than 51% shares are held by 51% or more, right? They're held by government. They are direct under the control of ministry. They are under the control of board. Here also we have board, right? and they get money through government budget. They have their own funds, and they also get share capital from government, plus they can borrow, like we read about all other companies, right? So this is how, and we have the examples. Okay, this is how you can see this, right? Are we supposed to learn this, ma'am? No, you don't need to learn this, but of course this particular part you need to learn, that when I talk about business organization, how government works. Okay, let me write two questions over here. So you can write it just on top of it, question, or you can write in your copy. What do you mean by social sector? Explain nature of business organization in India. Question: How do you categorize sectors on the basis of government ownership? Okay, so any of these sort, what you're supposed to write, these two: public sector, joint sector. In public sector, we have these three classifications. Is that clear? Okay. Okay, now we will actually begin with the Companies Act. I told you that the first chapter, that is preliminary, has only two sections, section 1 and section 2, right? So section 1 is all about applicability, short title, extent and commencement, which we have discussed, and section 2 is all about definitions. So we have so many definitions that we have to read in this particular chapter. Ma'am, are the definitions important? Extremely important. In fact, some definitions are marked as very important, which you must learn from exam perspective. Okay, not just for the direct questions, but also the case-based questions are asked from the definitions, like the definition of private company, very important. Okay, so let's begin with a new topic: classification of companies. We can classify the companies on a lot of bases. Okay, the companies which are registered under the act, they're called as companies. The companies which are not registered, like we have the statutory corporation, which we have just discussed prior here, statutory corporations. They are like SBI, RBI, LIC, etc., etc. This is not supposed to be learned by you. Okay. Next, we come on the basis of liability. We are going to only talk about the registered companies in this chapter, because any company which is not registered is not a company according to Companies Act 2013. So we are going to talk about registered companies only. Now, there could be an unlimited company or a limited company. If it is a limited company, it could be a company limited by shares or limited by guarantee. If it is a company limited by guarantee, it could be with share capital or without share capital. Right? So, ma'am, have we read this before? Of course, you have read this before. I'm not talking about the previous level, like you have read it at inter. No, I'm talking about we have just read it in the previous class. I told you the concept of limited liability. So now my question is to you: if there is a company limited by shares, the liability of the company will be limited or unlimited? Unlimited. The liability of the company will be unlimited. The liability of members will be limited. Limited to the amount unpaid on shares held by them. Is that clear? If it is a company limited by guarantee, the liability of members will be limited to the amount as they have undertaken to contribute to the assets when the company is being wound up. So if at all the company winds up and then there's a shortfall, it is not able to repay its liabilities, the assets are insufficient to repay the liability, so the members who have undertaken the guarantee, they will contribute, right? And the guarantee amount, if it is 5 lakh, the liability is only 5 lakh. Yes. If there is a guarantee company with share capital, then you club both of these. That means my liability is the guarantee amount plus the unpaid amount on shares. If it is without share capital, only the guarantee amount. See, this is something that I've told you before. Okay, so I'm not elaborating this particular concept. Okay, when I talk about unlimited companies, the company which does not have any limit on the liability of its members. So all your personal assets get attached to meet the obligations of the company. Got it? Fine. So I don't think there is any confusion. It's all clear. Okay, now. On the basis of members. In fact, when we go on to read section 3 plus section 7, this is about formation and incorporation of company. We get to know that a company can be formed as public company with 2 members, public company with at least 7 members, private company with minimum 2 members, and or 1-person company with 1 member. So according to Companies Act 2013, there can be only 3 types of companies which are formed: public, private or OPC. That means, ma'am, we talk about government company. Well, government company can either be public or private, but it has to be something. So accordingly, if you're forming any company under Companies Act, it has to be public, private or OPC. Public, private or OPC. There is no 4th choice that you have. Any company that we talk about, we may talk about a banking company, we may talk about an insurance company, we may talk about a government company, we may talk about a small company. It has to be either of the 3. You get it? There are restrictions. We talk about Section 8 company. There are everything which we'll talk about. So in today's class, the first thing that we are reading is about a private company. Very important. So we are going to give this a good heading. Write down classification of companies. Classification of companies. And then the first one is private companies. Okay. Private companies. Now, you all know that private company means a company with minimum 2 members. Okay, so first of all, I am going to ask you certain basics and you will just try to respond. Fine. When I say private 8, it is section 2, clause 68. Ma'am, do we need to learn this? Yes. Ma'am, do we need to learn all the 470 sections and thereafter the subsections and everything in Companies Act? No. So, ma'am, which sections are we supposed to learn? I'm telling you. I'll keep on telling you. Okay, there's also a list of important section numbers. Everything is there. Don't worry on that part. But this is the first section that I'm telling you to learn. Section 2, clause 68, private company. Private company basics: minimum members, maximum members, minimum directors, maximum directors. So minimum number of members, 2. Come on everyone. Maximum number of members, 200. Minimum number of directors, 2. Maximum number of directors, 15. If you don't know, we'll be reading more about it when we read the chapter of directors. But right now, this is what we know. This is what we know. Apart from that, we also know something. We also know something like what we know. When we were discussing about the feature of transferability of shares, I clearly told you that, like, if I form a company with you, right, or let's say there are two students and me, and I formed a company, and you all trusted me, you all trusted my vision, and someday I sold the shares to somebody else and I walked away, right? Do you think it is fair? No, we need to discuss. We need to take consent from each other. Why? Because you cannot transfer the shares just like that. So the shares of a private company are not freely transferable. They can be transferred subject to certain restrictions. Subject to certain restrictions. Okay. Now I'll ask you another question. Tell me one thing. When I say private company and public company, which one is bigger? Ma'am, public company. That means you want to say that private company is a small company and public companies are big companies. Well, one of the biggest companies that we have, Flipkart. Like, even we have bigger companies than that, but it is a company which every household knows. Flipkart India Private Limited. Now, Flipkart is a private company, yes. Yes. That means the myth that private company means it has to operate within this limit only, no. It can go big and bigger and bigger. There is no limit. That means private company could be as big as any public company. It could be as big as a listed company. Yes. So private companies are not small companies. Okay, ma'am. Then what are private companies? I mean, what is it that differentiates it from public company? It's private space. That means if Flipkart needs money, it cannot go to public and say, you give me money and take the shares. You invest in me. I'm asking every public that I am just giving one share of 100 rupees. You take one share, give me 100 rupees. So it cannot go to general public to raise funds. Why? Because there's complete prohibition on private companies, that private companies, you cannot invite public to subscribe for any of the securities. Got it? Okay, ma'am. So private companies restricts transferability of shares. That means the shares can be transferred but subject to restrictions. They are not freely transferable. Okay. It prohibits invitation. It cannot go and invite public to subscribe to its securities. That means, ma'am, if a private company needs funds, where will it go? Well, it can go to any person, like Flipkart went to Walmart. Kind of, right? So it can go to any person, and like maybe if you and your friend have opened a private company and you are in need of fund, you can go, you are in need of funds, you can go to a bank, take a loan. You can come to me, ask me to purchase your shares, be an investor, but you cannot ask general public to be the investors. You can never make a public offer. You can never go for IPO. You can never go for any public offer. Got it? Okay, ma'am. Fine. Ma'am, is there any requirement of minimum funds that we need to invest to form a private company? Like tomorrow, we will become professionals and we might want to start our own business and we might want to form a company. So me and my friend, we both decide to form a company. So how much funds will be needed? Right? Private company means a company with minimum paid up share capital as prescribed, and which by its Articles of Association restricts, prohibits, and limits. This is the definition of private companies. That means, ma'am, if I want to form a private company, I have to have the minimum paid up capital as prescribed. The question is, what is prescribed? Whenever throughout Companies Act you read the word prescribed, you have to know that it is something which central government will tell us and not the act of parliament. Okay. So what is prescribed? We go to central government and we ask them, what is prescribed? Central government will tell us that I work through my ministry and the relevant ministry is MCA. Go to MCA and ask. So we go to MCA and ask, what is prescribed? MCA says, I have not prescribed anything right now. That means right now, if I want to form a private company, I can form with any capital. Yes, even with 10 rupees. Yes, why not? No minimum paid up capital has been prescribed. Of course, when you're making a company with shares, there has to be some shares, right? So no, earlier, back in the old times, it was prescribed. It was 1 lakh, 5 lakh for private and public. But now we don't have any such requirement. So private company means a company with minimum paid up capital as prescribed and which by its articles of association, that means when you open this document, articles of association of this company, there will clearly be written that we restrict the transferability of shares. The shares can be transferred subject to the following restrictions. The company is prohibited to invite public to subscribe to its securities and it limits the number of members to 200. Maximum number of members in a private company can be 200, not more than that. Not more than that because it's a private space. Come on, right? Is that clear? Okay. Now, I'll ask you certain more things. Fine. So we have a company ABC Private Limited. It has 199 members. Okay. There's an example that we have taken up. We have 199 members. Company wants to issue 10 shares to Mr. X. Okay. Can it do so? Yes or no? Now there might be a slight confusion amongst the students. Ma'am, 199 plus 10. That means it's increasing. It's going beyond 200. So it cannot do so. Come on. Get this crap. I never said that a private company can give only 200 shares. A private company can have maximum 200 shareholders. A private company can have maximum 200 members. The question here or the confusion here also floats in when the students don't know basically that what is a subscriber, what is a member, etc., etc. So we will just skip this and I want you to know something else also. So we have a company and the company takes decisions. Please write this. Please write this for knowledge only. Write the heading for knowledge only and write this. Company takes decisions through board of directors who are elected by shareholders. Yes or no? Yes, ma'am. Some decisions are also taken by shareholders who invest oblique, you can all shareholders or members, you may say, who invest oblique take guarantee. These shareholders could be an individual. That means if I want to buy the shares of a company, I can buy the shares of the company. I can be the member of a company, right? It could be a body corporate also. That means if LIC wants to hold the shares of any company, they can. Yes, if you open the shareholding of ONGC, you will see that LIC is also a shareholder. So can LIC become the shareholder? Yes, why not? Can a company become the shareholder of another company? Why not? Firm, no. A firm cannot be a shareholder or member of a company. Except for Section 8 company. Yes, I know, but that I'll discuss later. Okay, so this is one basic. Second basic. Let's make a timeline. Okay. So here, company is incorporated. When the company is incorporated, after some time, there will be shares issued. Okay. And maybe some point later on, the company may be wound up. That is, winding up takes place. Now listen to me very carefully. Today, if you want to incorporate a company, okay, today you want to form a company, you have found two friends, you are about to form a company, will you be called as the member of the company? No. Why? Because the company does not exist. So when there is no company, how can you become the member of the company? You cannot. So what will you be called as? You are about to sign the document. You are subscribing to the document that I agree to become the member. So you are called as subscriber before the company is incorporated. Once the company is registered, the subscribers actually become the members. So now you're called as the member of the company. Then the shares are issued to you, money is taken from you. So when the shares are issued to you, you become the shareholder. You can also be called as the member still. Okay. Once the company is wound up, that means the company is now going to be closed, shut down, etc., etc. So when that order is passed, after that you're not called as a member, but you are called as a contributory. So a same person in his lifetime can be the subscriber, member, shareholder, and contributory of a company. Got it? Got it? Okay. So now we come back. We come back to the definition of private company. So now my question is back. There's a private company, it has 199 members. Company wants to issue 10 shares to Mr. X. So if the company issues 10 shares to Mr. X, then there will be one more member. That means there will be 200 members. Is it allowed? Yes, it is allowed. A private company can have maximum 200 members. So can it do so? The answer is yes. Okay. But Mr. X says that I will hold these shares jointly with my wife. Oh my God, what love. Jointly with my wife. He could have done two things. Point number one, he could have held 5 shares in his name and 5 shares in the wife's name. If he would have done this way, then there would be 2 shareholders, Mr. X and Mrs. X. But what he said is, I will hold these 10 shares jointly. That means they are joint shareholders. So these joint shareholders will be considered as one. So even if you want to hold shares with your in your wife's name or jointly, then fine. Still it's allowed. Still it is allowed. Got it? Yes, everyone? Okay. So the first point that I have cleared over here is that the joint holders when two or more persons hold any one share or any more shares jointly, then they will be treated as single member for this purpose. Clear? Okay. Now, next example. Example number 2. Next example. A company has 150 members. A company has 150 members. Can it issue shares to its employees, to its 60 employees? Yes or no? Imagine a company as big as Flipkart. It may not have a lot of members, but it has n number of employees. Come on. There are so many people working day and night in the company. Now, this particular company, or any company as of that matter, right? If they want that, okay, my employees should also feel motivated and they should work towards the growth of the company. If I'm giving them cash bonuses, it's fine. But if I give them shares, they will be motivated to increase the value of the company, because if their share price is increasing, they are also gaining more profit, right? So they will work in that manner. So a lot of places we know that employee stock option plan, right? And employees are being offered the shares of the company at the discounted rates, right? So that employees also become a part of the company and they also work towards the growth of the company. So this is a company which already has 150 members and it wants to issue the shares to its 60 employees. Can it do so? Well, ideally, if I like count like this, 150 plus 60, it will go to 210, which is not allowed. Yes or no? Yes or no? Yes, ma'am. But then this will not be counted. Why, ma'am? Because imagine a company like Flipkart, they will be of the view that I have so many employees, why can't I issue shares to the employees? I'm not raising funds from all these employees. There's this different perspective. There's a different perspective, right? So why not? That means, ma'am, it can issue shares to these 60 employees. The answer is yes. So how many members will be there in the company? 4. How many members will be there? For section 2 clause 68, 150 members. For other sections, 150 plus 60. That is, employees will get voting rights, dividend, etc. That means it is not so that we are not counting you as the member, so you will not get any dividend, you will not get any voting rights. No, just we are not counting you in the limit of 200. If we count you in the limit of 200, there will be violation of section 2 clause 68. But section 2 clause 68 clearly states that persons who are in employment of the company and persons who were employment of the company but have discontinued the employment, they shall not be included in the number of members. Okay, they will not be included in the number of members. Fine. So otherwise they will be entitled to all other benefits. It's just that when we are counting the number of members, they will not be included. Got it? They will not be included. Is that clear, everyone? Okay. Let's now read the definition. Private company means a company having minimum paid up share capital as may be prescribed and which by its articles restricts, limits and prohibits. Restricts the right to transfer its shares except in case of one-person company, limits the number of members to 200 and prohibits any invitation to public to subscribe for the securities. Provided that where 2 or more persons hold the shares jointly, they shall be counted as one member. And provided that persons who are in the employment of the company and who have been formerly in the employment of the company, like today I am in employment, I got the shares in that capacity, now I left the company and have joined another company, so that means I will now be counted as in the member? No, I'll still not be counted, even if my employment has ceased, even if I'm not an employee. So current employees as well as ex-employees, they both will not be counted when we are computing the limit of 200, and joint holders will be counted as 1. Okay. No minimum paid up capital requirement according to the rules. Minimum number of members 2, maximum number 200, right to shares restricted, right to transfer shares restricted, prohibition on invitation to public to subscribe to security. Small company is a private company that we'll discuss later. OPC can be formed only as a private company. Again, we will discuss later. Private company needs to have minimum 2 directors. You all know that. Is that clear? Yes? Okay. So that's it with today's class. And we'll have a quick recall and then we'll move to the next type of company. Right? Thank you.